Hello and welcome to Forensic and Investigative Accounting, Chapter 8, Litigation Services Provided by Accountants. First, we're going to start out by looking at U.S. tort costs. So in 2016, we had U.S. tort costs that were close to $260 billion, or about 1.68% of GDP. That is slightly lower than our costs in 2010, which were $264.6 billion. What that equated to in 2010 was $857 per U.S. citizen, which pales in comparison to $12 per U.S. citizen in 1950 and about $833 in 2008. So now what is of most concern is that the medical malpractice cost totaled nearly $30.3 billion in 2006, which is about $101 per person compared to that of $5 per person in 1975. So we have 6 major phases of litigation, including proceedings, discovery, pretrial conferences, the actual trial, outcomes, and possible appeal. Much of the work of forensic accountants occurs in our discovery stage. So when we're at the pleadings, we have a complaint, which is that filed by the plaintiff. Then we have a service of process, which is actually served. So that complaint is served to the defendant. Then the defendant must either admit or deny those allegations via an answer. Then we have a demurrer, which is no cause or action exists. But also when you file a complaint, you might also have a cross complaint where the defendant would file a complaint against the plaintiff. There are several methods of discovery: interrogatories, depositions, which are among the most common. We have admissions of fact. We have a request for production, subpoenas, and also we can ask for documents and question their authenticity. I really enjoyed this little clip here, and it actually shows, I'm not sure why my marriage ended. I'm still waiting for the forensic report. So I thought that would be a nice comic relief into the rest of our lecture. Let's talk about civil procedure. These are the body of rules and practices by which the justice and the legal system is handled. So here we have federal rules of civil procedure, which we will refer to as FRCP, Federal Rules of Civil Procedure, and that is governed by the U.S. District Court. Then we have Federal Rules of Criminal Procedure, but for us forensic accountants, we are most concerned with Federal Rules of Evidence. So the type of litigations that we provide, those services that we provide as accountants, are typically we serve as a consultant. Ideally, we serve as expert witnesses. We might also be court-appointed experts or special masters, but our common role is that of expert witness. Now, the standards of our conduct that we must adhere to in order to perform these litigation services is SKEET, S-K-E-E-T. So we have skills, we need to have the knowledge, the experience, the education, and the training to perform these litigation services. As forensic accountants, we also must adhere to our professional code of conduct. We must ensure that there is no conflict of interest between ourselves and the attorneys and our clients. And additionally, we have a written agreement to perform these litigation services similar to that of an engagement letter in an external audit. Now let's discuss the expert and the lay witnesses. So a lay or a matter-of-fact witness basically testifies to the facts of the case. As forensic accountants, we tend to serve as expert witnesses, which is we have specialized training or experiences, and we are allowed to testify in court mainly to help a judge or jury understand the complicated and technical subject of accounting. We might also use summary witnesses to present a large amount of data and complex data. So in order to qualify as an expert witness, under the Frye standard, basically the test for admitting an expert testimony, in order for us to qualify, we need to state that we as expert, our testimony will assist the trier of fact in the understanding of the evidence in order to determine fact within the issue. Additionally, we have to attest to the theories and or the techniques that we relied upon as an expert that are generally accepted within our accounting community. And then we also have to state that ourselves as an expert, we are qualified to present this testimony. Additionally, as accountants, we have this testimony. We're hoping that this testimony will help the judge understand the evidence or determine the fact. This is also under the federal rules of evidence. Additionally, as an accountant, we need to qualify with our knowledge, our skill, our experience, our training, and our education, going back to that SKEET acronym. And then as an accountant, we need to show that our testimony is based on fact or data, and it will be the product of reliable principles, and that the method that we have applied is also reliable. So we're going back to our qualitative characteristics of accounting and reliability here. So now we have in Daubert versus Merrill Dow Pharmaceuticals, the U.S. Supreme Court established the rule for federal courts that now trial judges, they have a special responsibility to ensure that scientific testimony is not only relevant but reliable. Keep in mind that relevance and reliability are two of the qualitative characteristics of accounting. We also have in the Kimono Tire Company case versus Carmichael, the Supreme Court also decided that the judge now has a gatekeeping obligation that not only applies to scientific testimony but also applies to expert testimony. So in order to qualify as an expert witness in Daubert versus the U.S. Supreme Court, they suggested that in this verdict that the judges have to consider these factors. So is the theory or technique in question tested, or has it been tested? And whether that theory or technique has been subjected to a peer review and publication, or any known or potential errors, and what rate of that error. Additionally, the judge also has to note whether the theory or technique has attracted any acceptance within the relevant community. So in our case, that would be forensic accounting or accounting in general. So then we have that in the article, the CPA's expert witness role in litigation services, a maze of 10 legal and accounting standards. Here are 10 guidelines that a forensic accounting or an expert witness can follow to help avoid any legal challenges. First and foremost, as an expert witness, you need to know the professional standards. You not only need to know those standards, but you need to know how to apply them. You also need to know the professional literature and the organizations, the professional organizations surrounding the case. Then you have to understand generally accepted analytical methods. So in our case, probably GAAP. You also have to be very familiar with multiple analytical methods and be able to synthesize the conclusions developed and derived from those analytical methods. You need to disclose your assumptions and variables within the use of these methods, and note that your analysis has to be subject to peer review. You also have to test the analysis and the conclusions that you derive from these analytical methods for reasonableness, similar to what we would do in an external audit in conducting a reasonableness test. But if you follow these 10 principles, then you are less likely to hopefully have any issues while you're serving as an expert witness. Now, as an expert witness, you have to issue a report, which in forensic accounting is usually known as the final fraud report. This report has a name and a docket number for the case. It also states your qualification, and it also gives the information that you utilize to render your opinion. Within that information, you should list other cases in which you as an individual have testified as an expert witness in the preceding 4 years. You must disclose your compensation received for your testimony and your consulting services. And more importantly, the end result of your final fraud report is your opinion that you're expressing and the reasons as to why you're expressing that opinion. So when you're preparing to actually testify as an expert witness, keep in mind that you have to be independent from the client. So similar to an external auditor, independence is paramount here. More importantly, the evidence in which you rely upon has to be error-free and very succinct and concise. Any use of confidential client information should be stated. You, as an expert, have to issue a report and the related working papers, exhibits, and other type of evidence that you're using within your report. And if you've used any other expert's evaluation, that has to be included in your report as well. So when you are testifying as an expert witness and you're doing so in a deposition, you will probably have to disclose the scope of your assignment, your current employment, your title, your duties, your educational background, any certifications and license that you have, and as to their status, your overall work experience. In addition, any memberships to professional organizations such as the ACFE, the Association of Certified Fraud Examiners. You must list your publications and invited lectures and the fields in which you are qualified to serve as an expert or any other work that you've done as an expert witness or a litigation consultant. You also have to give your compensation that you are receiving and what percentage of that compensation, your total compensation, is derived from expert witness testimony. So not only do you have to give the discrete and absolute dollar amount, you also have to give the percentage of your overall compensation. But the crux of your testimony and in your deposition is your opinion, the basis for which you have derived that opinion, and anything else that you can possibly be asked will be asked through that deposition process. Now, when you are actually cross-examined, this is where you have to be cautious as an expert witness. More than anything, you do not, under any circumstances, do not speak to anyone outside of the courtroom while you're waiting or within breaks. These individuals can be jurors and people to testify, so you want to keep a tight lip. Do not speak to anybody outside of the courtroom. Be sure you shut off your cell phone. Make sure that you don't wear any emblems or advertising. And as a word of caution, you do not want to use humor. Obviously, you want to laugh at the judge's humor, but I would avoid using humor on the expert witness stand. Keep your hands on top of the table, not hidden, and be sure that your attorney questions you in detail about your qualifications. Your qualifications are what's going to impress the judge and jurors and hopefully help solidify you as an expert witness. Do not allow the other side or opposing counsel to stipulate you as an expert. That should be normally completed by your attorney. You want to dress neatly and conservatively, arrive on time, and when you're taking the oath as a witness, say loudly and proudly, "I do." You do solemnly swear to tell the truth, the whole truth, and nothing but the truth. More importantly, be sincere and respectful throughout your expert testimony. You want to talk directly to the jurors. If there are no jurors, you want to talk to the judge, look at them in the eyes, make contact. You want to explain the numbers carefully, possibly using analogies that they can relate to, such as your tax returns or your checkbook. If you pause, that does not harm you. Take a moment, pause, and think about what you're saying before you say it. Typically, we like to speak in the first or active person so that you as an expert reviewed the records and the documents. You found the following situations or anomalies. You want to tell stories about the people that you are actually including in your final fraud report. Be careful, though, when opposing counsel tries to show you passages from textbooks. They are definitely not your friend, but your foe, so be cautious when you answer those. Also, jurors may have quite a little bit of to do within long periods of time, so they're very observant. So be careful about your demonstration of your behavior in the courtroom, outside of the courtroom, while you're driving, etc. You never know who's a juror and who might be observing you. And when you are in trouble in the courtroom, if you feel under pressure while you're being cross-examined, do not lean back and take a relaxed stance. Instead, lean forward, be authoritative, show that you actually know what you're doing. And when you are finished with your testimony, you are not allowed to leave the courtroom until there is a break. Now, while you're testifying, there's a great article that ethical and effective testimony during direct examination and cross-examination post Daubert. So here the primary goals of an expert witness is you want to communicate the truth to the jury and or the judge in an ethical, objective, and effective way. But while doing that, you still want to maintain your authenticity, your autonomy, and your integrity. And you want to uphold these values because those are the values of the profession. You also want to interact with attorneys and the judge or jury in mutual respective fashion. You want to engage in dialogue with your attorney so that the two of you are actually a team and together, and the two of you can educate and lean off of each other, the judge and the jury, as to any questions that they may have, and hopefully you answer them through your testimony. You want to, as an expert witness, when you're testifying, to speak directly to the issues, but more importantly, you want to make complex issues more understandable, not oversimplifying them, but merely making these complex anomalies of number understandable to the judge and the jury. Expert witnessing does come with liability. You may have a threat of lawsuit, which are possibly claims of negligence. You may also be liable for breach of contract, for negligence, or any type of criminal process. So be cognizant of that. Now, there is a database called the Daubert Tracker, which you can look at, and it looks just like this, and it's a free service. And basically, it's a free tracking service. You can access it via this URL, daubertontheweb.com. And as of July 2013, we had 87 cases that was under accounting and economics. So accountants and economics that had an admissibility rate of almost 0.6%. So there's 25 fields with admissibility rates, and you see here listed appraisers, computer experts, criminologists, statisticians. So now let's move back to the written reports that we produce as an expert witness, which is our final fraud report. So as an expert, you should never draft a written report unless it has been expressly directed to you by the attorney that is hiring you, your hiring counsel. So if they request a written report, then you produce it. Otherwise, do not draft it. Keep in mind that the federal rules of civil procedure are what guides our written report. Additionally, do not destroy any interview notes, but do keep a diary of your interviews. This will help you in not only preparing your final fraud report, but showing and telling your story of how this fraud occurred. So your written report should have several contents. For example, any opinions that are expressed and the basis for how you're expressing these opinions. Data is paramount in your final fraud report. So all the data that you considered in formulating this opinion, and this data is usually presented through the way of exhibits or some type of summary format. Your qualifications as a witness, which you have to list all publications in which you authored over the last 10 years. Additionally, as we mentioned previously, in your final fraud report, you have to state your compensation and any disputes that you have as serving as a witness through your testimonies and depositions for the last 4 years. Lastly, be sure that you sign your expert testimony. So there are types of expert reports that we as forensic accountants generate. They are either fact-oriented or opinion-oriented reports. So fact-oriented reports, you gather and evaluate facts, and then you use them to prepare this report. So you're basically checking and rechecking the numbers and facts. An opinion report, which an example could be your valuation report or your final fraud report, this is a bit more subjective and it relies on your professional judgment. A combination of these two reports is among the most common that we as forensic accountants prepare. So let's talk a little bit about the trends and outcomes of the Daubert and Frye challenges as demonstrated through the PwC survey. So PricewaterhouseCoopers did a survey and they did searchable databases of Daubert and Frye challenges, and it showed from 2000 to 2014 there were 1,784 challenges, and basically they included 648 subdisciplines, which showed that accounting experts were ranked 9th in the most challenged experts. The economists were number 8 and police law enforcement ranked number 1. So over the past 15 years, we've seen a lack of reliability as the primary reason to be either Daubert or Frye challenged. So when Daubert challenges were appealed, the appellate courts agreed 70% of the time. And the agreement rate is lower if you were a financial expert, as that was pretty much excluded from the lower courts. Additionally, we saw twice as many Daubert challenges on the plaintiff side, close to 69% versus 31% on the defendant side. And the defendant side, financial experts, they experienced a marginally higher exclusion rate over the last 15 years. So challenges most often occurred when it be under the breach of contract or fiduciary duties. And over the last 15 years, we've seen that intellectual property, fraud, and bankruptcy disputes had the highest rate of exclusion from a Daubert or Frye challenge. And you've made it to the end of our lecture. Thank you for watching.